Firearm, not a firearm. How to tell the difference and build the anti-gunner's dreaded ghost gun on today's AK show.
This is Alex, AK Kincaid. Welcome to the AK show.
You can buy this piece of metal on the internet and have it delivered directly to your home, just like I did. This one will require a 4473, a background check, and delivery to you only from a licensed dealer or manufacturer. In other words, when you buy, you don't have to comply with this piece of metal. And the reason is, when you buy an 80% or an unfinished lower receiver, it's not a firearm. A lot of you may have watched my video on building a rifle at home, and remember one of my 3 rules? Build for your own personal use. If you want to avoid all the rules and restrictions when you finish a lower receiver into a firearm, you'll need to follow that same rule, because turning a piece of metal into a firearm for yourself is not regulated under federal law. So that brings us to the question of, what is a firearm? And that depends on what law you're reading. You'll see a link in the corner there to my book Infringe, where I go into this in a little more detail. But for purposes of our discussion today, and talking about a finished versus an unfinished lower receiver, we're going to focus on the federal law and the definition that's contained in the Gun Control Act. And here's the question. Can the weapon you're talking about expel, or is it designed to expel, or may it readily be converted to expel a projectile by the action of an explosive? Or is it the frame or receiver of such a weapon? And if so, it's a firearm. On the other hand, if it's just a receiver blank, casting, or machine body with a solid and unmachined fire control cavity area, like this, then the piece of metal is often referred to as an 80% or unfinished lower receiver, because the ATF says it has not reached the stage of manufacture, which would result in the piece of metal being a receiver, and therefore it's not a firearm under the definition in the Gun Control Act. So if this is not a firearm, it's just a piece of metal, and all the things you usually have to do when you buy a firearm from a dealer, tossed right out the window. Unless you're turning your lower into a firearm subject to the National Firearms Act, like an SBR, you also don't have to comply when you manufacture it by marking it with a serial number. And the government even regulates the font size when you do that. And what I mean is how deep it has to be engraved and how large that has to be and where it's placed. But if you're building this into a firearm for yourself, you don't have to comply with that. And this is why firearms are called ghost guns, mostly by the anti-gunners out there. They don't like them. They're not registered anywhere. It's a true ghost gun with no governmental eyes, knowing that you, the law-abiding American citizen, have one. And of course the ATF and law enforcement don't like this, because if a homemade receiver turns up at a crime scene, it's usually not possible to trace the firearm or determine its history, which they say hinders the investigation and therefore public safety, because they claim this prevents them from catching the bad guy. So they, of course, the government, recommend that you engrave your finished receiver with a serial number for later identification if it's ever lost or stolen. Now, there's an exception, of course, because California is leading the way once again with gun control. They've started passing laws in states that require markings on your finished lowers, even if you make them for personal use. California's law was passed in 2016. So now, when California residents complete an unfinished lower into a finished lower, a serial number will be required. But after July 1st of this year, you must first apply to the California Department of Justice for a serial number, pay a fee, and then they will assign you that serial number that you must engrave on your lower. So, there's a limited benefit for Californians, but for those of us who live in the free states of the United States of America, we're looking at federal law, and that's really what I'm focusing on in this video today. So, when does an unfinished receiver cross the line and become a firearm? First thing to know is that phrase 80% is meaningless to the ATF and law enforcement. It's advertising. It's not a legal definition. The question is whether the piece of metal that you have is unfinished enough to still be just a piece of metal in the eyes of the ATF and the courts, or is it a finish to the point that it's now a firearm? Where do you cross that line? This question still gets debated in court. And just a couple of years ago, in 2016, the ATF went after a dealer, had a license, he was a dealer, but he was selling receivers online and from his shop, and he had put different colored polymers in the cavities, which made it easier for his customers to mail them out and convert them into a firearm. And the ATF, of course, said, this is too easy. These are firearms. You went too far in finishing them. So how do we know? The critical part is what's called the fire control area. If you are drilling and machining the metal to accommodate fire control components, and you've completed that task, you can now put in a hammer, the bolt or breech lock, the firing mechanism, and it's usually threaded on the end to receive the barrel. Now the metal is able to be put together with other parts and used to expel projectiles. Remember that definition? As I've said before, just because you find something for sale, especially on the internet, does not mean it's legal. Just because something is being sold as an unfinished receiver doesn't mean it is. 80% lowers or unfinished receivers are not legal terms. They are not defined for us in the law. So be sure you know the difference before you buy. And if you're unsure, the ATF says you can contact them and you can ask, but also be aware that reputable sellers will often have a letter from the ATF certifying that they do not consider the seller's product to be a firearm. Okay, here's where people are getting in trouble. They start making money. They're making money from turning a piece of metal into a firearm, and they haven't paid a licensing fee to, guess who? The federal government. So they're not marking guns that are being distributed to the masses. They're not keeping the records that the government wants them to keep. And when they start making money, they get noticed, and then they get investigated, and then they get prosecuted. So when do you need a manufacturer's license? There are different opinions from our courts than from the ATF on what kind of a license is needed for what types of activities, and so that topic would be an entirely different video. Let's just say for today that the lines between what activity constitutes gunsmithing, dealing, and manufacturing have all been blurred by the court cases, the ATF rulings, and the laws. The bottom line for you to remember is to determine if you're in need of a license at all, look to whether or not someone's making money. And if you're not engaged in a business for profit and you're just making a firearm for your own personal use, we don't even have to get into a discussion of what kind of license you need, because you don't need one at all under federal law. For your knowledge, a manufacturer's license is required by someone who, quote, devotes time, attention, and labor to manufacturing firearms as a regular course of trade or business with the principal objective of livelihood and profit through the sale or distribution of the firearms that they are manufacturing. And I'm going to put a little note in the corner of the video to help you look that up if you want to read the actual law. But that quote is from the law. There's a little booklet out by the ATF to help you decipher what it means, and a video that I made to help you figure that out as well. Just remember, there's no magic number, such as if you're selling more than 5 items a year. The question is always whether you are intending to make a profit from what you're doing. And if you are devoting time and effort to making firearms and then selling them to make money, this is where the ATF will get interested in you. And it doesn't matter if it's 1 time or 100 times. If you are making firearms with the intent to make a profit, you need a license. And here's what people were doing. They'd take their unfinished receiver to a machine shop and they'd have them finished there. Machine shops are not usually licensed manufacturers, okay? And some machine shops would even let you sit down and use their equipment. They would often set up a machine called a computer numeric controlled machine, and you could sit down and finish your blank or frame or piece of metal into a receiver that could be used to assemble a weapon capable of firing projectiles. Your local machine shop cannot avoid getting an FFL by allowing you to use its machine if the machines and equipment are under its dominion and control, where the machine shop controls access to and use of such machinery or equipment. And I took that quote right out of a ruling by the ATF. Finishing a lower into a firearm for someone is not just gunsmithing. The ATF says it's manufacturing and you need a manufacturer's license because the weapon is being made by turning this into this. So think about it. If you finish a lower, you're not repairing it or improving it. You're not gunsmithing. You are making the actual firearm. And if you do it for a profit, you need to be licensed and you need to comply with all the laws that go along with being a licensed manufacturer, such as marking the finished firearms before transferring them and maintaining manufacturer's records. The bottom line is, you can't go to an unlicensed machine shop, give your blank to a gunsmith, or even use a booth at a gun show anymore that's hosted by a dealer to finish your receiver and avoid the markings. And if you have friends who come over and want to use your equipment in your garage, and they pay you to use your equipment to finish their lowers, you may find yourself noticed by the ATF. And again, if you're noticed, investigation, prosecution, and conviction will likely follow. You can go online to the ATF's case profiles on their website at atf.gov. Look at the cases. Look how they're going after people for finishing receivers and making money. Be very careful because you don't want to be that guy. They have made it very clear that selling out of your garage or using someone else's equipment is not allowed. If you want to finish a receiver into a usable piece of metal, do it yourself and do it for yourself. Now that you have that knowledge, you have the power to avoid being that guy in the ATF case profiles. Until next time, stay vigilant, and as always, thank you for watching The AK Show. Get Alex A.K. Kincaid's book, Infringed, The Gun Owner's Guide to Gun Rights.
This is Alex A.K. Kincaid, and thank you for watching The AK Show.